Shenanigans at every corner, sarcasm a holy sermon in style, dark chocolate melted chaos warmer. Fighting this timeline with snark, every soul welcome but no recorders, baptized by laughter in the dark. We stand tall, scorning fake orders. In the church of glory rise, with chaos and shenanigans bright, chocolate and sarcasm uprise. Together we light up the night.
Welcome, guys. I am having problems with X. I did buy the premium, but apparently I only bought 1 month and not the subscription, so I had to go in there and like do the little things. And now they're rechecking me out to see if I'm worthy of a blue check mark. And because I paid, I will be. Welcome, Wolfram, and everyone who is lurking. This is going to be a stream. We are probably not going to get through the entire 83-page "you done screwed up" memo. It's, even if I were able to talk at the speed of Ben Shapiro, I think I'd only get about halfway done. This is going to go into an overview of the case. It's going to go through what the judge deems as her being an absolute butt monkey. That is not a legal term of art. That is a Mo term of art. But it will break down every sort of sanction and bad thing that this DA did in the course of trying to get Barry Morphew. Now, as I have said before, disclaimer, this is my first look into this case. I thought it was relevant to look at the DA's part of this case before I dove into the actual investigation, because I want to have a feel of how the investigation went. Can I rely on the state troopers? Can I rely on this? Do I need to look at alternate sources in order to get, maybe the truthier truth? I do not know if red solo cups were available. I do, however, know that they are the gold standard of evidence collection. So let's get into this. Supreme Court, State of Colorado, original proceeding, discipline before the board, and all of that jazz, fun headline stuff. You know, the stuff that we barely pay attention to. We're just like, let's get to the Matlock moment. Any hoozle. Sorry, I was moving things around on my screen so I can better see the document without having to strain my neck, because, on a personal note, I am stalking, in a good way, the delivery person that's supposed to be bringing my medication so that I can actually receive it this time. So I am trying to pay attention to multiple things, and we know that is a recipe for disaster. So let's get into this. Opinion opposing sanctions under Colorado rules of, professional conduct. So that would be section 242.31. This is against Linda Stanley. She was the head DA. Now, while she was more like it's either Fannie or Fani Willis. I think they're both hilarious. So she's kind of like the head that was supposed to be watching this team. So she was a bit like the coach, which is possibly the only sports ball reference I will put in. Following the highly publicized disappearance of a Chaffee County wife and mother, the newly elected district attorney of Colorado's 11th Judicial District, Linda Stanley, she will probably be referred to as the respondent in all the rest of this document, but she is Linda Stanley, brought first-degree murder charges against the woman's husband. During the prosecution, the respondent made 3 improper extrajudicial statements about the case to the media. Well, I mean, can we blame her?
Probably since I was 8 years old. So maybe 11 years, just about.
How
years old?
Yeah.
11?
The judge is like, you knew her from when you were a little youngling? A youngling? How strong is the force within you, Anakin?
I'm just doing, are you 19 years old?
Oh, no, wait a minute. Oh, my God. I'm like, wait. I'm actually not good at math. That's why I'm a law.
You know, not all of us are good at math. Not all of us are good at, being a ethical DA. And I have a surprise. At the end of this, I have a surprise for you. The irony is too good not to comment and not to read this particular piece of absolute BS. So I do have a surprise for you at the end. Congratulations. You guys are the, gajillion stream. Which threatened to prejudice the defendant and undermine the public's interest in justice. Those statements contributed in part to a judicial ruling changing the venue in the case. At the same time, the respondent did not adequately supervise the prosecution of the case. She failed to timely direct adequate administrative resources to the process of discovery, leading to a series of judicially imposed sanctions against the prosecution for discovery violations. She failed to make reasonable measures to establish a leadership structure that ensured accountability within the prosecution team, with the result that important projects in the case fell through the cracks. And she failed to intervene when the prosecution team was given an opportunity to cure its deficit endorsements for expert witnesses, the majority of whom were eventually excluded. I mean, these are basic things. She did not ask for more money from the state or from the county to, facilitate having all the people that you would need on a very, digital forensics heavy case in a heavy, you need investigators, you need experts. If you didn't have a body, you need people that will, explain to the jury why, even though you don't have a body, it's beyond reasonable doubt that this happened because X, Y, and Z. You need these experts if you don't have a body. Now, I realize that Suzanne Morphew's body was found, but again, she was the captain of the ship and she sailed it like the Titanic on steroids. After the presiding judge issued several adverse rulings less than 2 months before jury selection, respondent instructed her chief investigator to interview the judge's former spouse to determine whether the judge committed DV, laid hands on his ex-wife, even though she had no credible evidence to believe that the judge had ever engaged in such conduct. Respondent ordered the investigation in an effort to uncover information about the judge that would require him to recuse himself from the case. Shortly after the interview, which revealed that the judge had never laid hands on his former spouse, the respondent dismissed the case without prejudice. In a bid to rehabilitate her relationship with the media, the respondent later agreed to sit for a videotaped interview with a local reporter. During that interview, which the respondent reasonably should have known was on record and would be publicly disseminated, she again made improper judicial statements about two defendants criminally charged in the death of a 10-month-old baby. Now, this one ticks me off, guys. This one really, really bothers me because you just probably nuked any viable case that could have happened should there be evidence that these two people did this to this poor precious baby. She just took away the justice this baby could get on earth because she wanted to run her mouth. She effectively pronounced one of the defendants was guilty, revealed inadmissible details about the defendant's sexual-based juvenile offenses, and impugned the motives and character of both defendants. Two judicial officers ruling independently and concluded that the respondent's extrajudicial statements amounted to outrageous government conduct, so severely prejudicing the defendants that the judiciary was required to dismiss each defendant's criminal case. They're not going to get charged. No justice is going to be seen by that case because she wanted to run her mouth. Taken in totality, a majority of the hearing board concludes that these ethical violations warrant the respondent's disbarment. Procedural history. This matter began as proceedings under CRCP 242.22. Later on October 30th, 2023, Aaron R. Christofo and John P. Blaswitz of the Office of Attorney Regulation Counsel, the people in this case. So this goes up before a committee, from how I understand it, from what I looked up. It goes up to like HR of lawyers, and then HR of lawyers decide, okay, this is, again, from what I understand, so take it with like a pound and a half of ramen noodle seasoning and enough sodium to, well, attract deer. But if they agree that there's been misconduct, it goes up to the Supreme Court. Again, this is how I think it works. If we ever get any lawyers in the chat, I will ask. But basically, they then filed a complaint with the presiding disciplinary judge, Byron M. Large, the PDJ. So these are how these people will be referred to in the rest of the document. So it does kind of give you an outline of sort of the shorthand that they use. Bringing 7 claims against the respondent that alleged violations of 9 Colorado rules of professional conduct. Colorado Rule of Professional Conduct 1-3, Claim 1. The next one is Colorado RPC 3.6, Subsection A, Claim 2. RCP 3-0.8, Subsection F for Claim 3. So these are all the claims and enumerated and how she violated based on the subsections. Okay, procedural history. Again, Stephen L. Jensen entered his appearance as the respondent's counsel on November 13th, 2023, and answered the complaint on the respondent's behalf on December 18th, 2023. On January 2nd, 2024, the PDJ, or the judge, held a scheduling conference with counsel who appeared via Zoom. At that conference, the judge set a 9-day disciplinary hearing to take place from June 10th to the 21st, 2024. Now, I will tell you guys that 9 days for a hearing, I mean, we did our entire trial when I was in jury duty, not that I have vast experience, in about 3.5 hours. So this woman has all of the things to answer for. And it said, though the judge initially scheduled the hearing to begin each day at 9 a.m., the parties agreed in a pre-trial conference to advance the start time each day to 8:30. I do love how some of these footnotes are just like, we are lawyers and we like to document everything, because I am almost too type A to function and I would do this. The respondent moved to disqualify the presiding judge on January 16th, 2024, and the judge denied that motion on February 5th, 2024. On February 15th, 2024, the respondent moved the judge for an order requiring the people, so this would be that committee, to prove their claim as to Colorado Rule of Professional Conduct 1.3, Claim 1, under the heightened standard, arguing that Colorado Supreme Court decision in Attorney C, so this is a Colorado case that she believes is going to bolster her case, requires the people to demonstrate a mens rea of intent as to the claim. 3, see respondent's motion to resolve the legal issue of applicability of the standards in the matter of Attorney C to people's alleged violation of Colorado Rule of Professional Conduct 1.3, February 15th, 2024. Now, I do believe that the judge told her to go pound sand. That is a legal term in Mo's world. 12 days later, the respondent moved to dismiss claim number 5, alleging that Colorado Rule of Professional Conduct 8-4, subsection A and D. In that motion, the respondent challenged Claim 5 on the ground that it fails to state a claim, violates the separation of powers doctrine, and is void for vagueness. Alternatively, she argued that the judge ought to require mens rea of intent as to claim 5. Ma'am, you went on television and ran your mouth. You intended to talk badly about these two, people who, and this man. I mean, these are not like we have no evidence, ma'am. We have CVS length receipts. It's not like we are trying to, josh with you or lie to you. No, you went on daggone television. You went on to YouTubers. You signed into YouTube comments with your own damn name, ma'am. You didn't even go like Mistress Kickass or something, like a cool name. No, you went with your own name, which people can interpret as you co-sign this YouTube channel who has been saying Barry was guilty from the beginning. Or to impose no sanction because the claim presents a matter of first impression. The people lodged their opposition to each motion in responses filed respectfully on February 27th, 2024 and March 12th, 2024. The judge decided that the respondents' 2 motions in an omnibus order. So the omnibus order resolving questions of law under the, professional code of conduct. And he denied the respondent's motion to dismiss claim 5. It was a sad day for her. And that was on April 9th, 2024. So the judge essentially told her, pound sand, ma'am. In that order, the judge first determined that the alleged discovery violations at issue in Claim 1 were not subject to attorney's fees holding and thus refused to import an intentionality standard to that claim. So basically, the very niche case that she decided to pick in order to say, no, you need to add, a guilty mind to it. He's like, no. This has nothing to do with this particular claim. Find a different case, ma'am. Now, again, you would think 2 lawyers in a room would know that, hey, this isn't going to fly, but they tried it. Welcome, Antique and Christy Marie. Let's see here. And the judge also ruled that the people only need to prove the elements of, Rule 1.3 to meet their burden on Claim 1. They don't need to, prove that she had a guilty intention or wanted to do harm. The judge then denied the respondent's motion to dismiss Claim 5 on procedural and substantive grounds. The judge first found that the respondent's motion to dismiss for failure to state a claim was untimely and that in any event, Claim 5 sets forth facts that, if taken as true, provide plausible grounds for relief. The judge next determined that the respondent failed to demonstrate that the people's claim number 5 is constitutionally impermissible. And finally, the judge concluded that alternate forms of relief the respondent requested were inconsistent with the rules governing Colorado's regulation system. So all of that to say, he said, nah, we're going to trial. From June 10th to the 21st, 2024, a hearing board comprising of the presiding judge, lawyer Sherry A. Colia, and a citizen member, Melinda M. Harper, held a disciplinary hearing under the Code of Conduct rules in Colorado, or in courtroom 2A of the Lindsay Flanagan Courthouse in Denver, Colorado. Christofko and Blazowicz attended for the people, and the respondent appeared with her counsel, Jensen. The hearing board received an in-person testimony from Jeffrey Lindsay, Alex Walker, Daniel Edwards, Mark Hurlbert, Robert Weiner, and Ramsey Lima. Now, I want you to remember Ramsey Lama. Sorry, I keep calling you Lima, sir. You're just Lima in my heart. I'm sorry. This is the judge that she tried to find Oppo research on, tried to accuse him of laying hands on his ex-wife and ruling against the prosecution because he wanted to be passive aggressive against his ex-wife, who ran I believe, Justice for Suzanne Morphew kind of, social media thing. So the DA was like, no, it's not because my team sucks out loud. This judge is obviously trying to hurt his ex-wife. Andrew Corey, Stan Garnett, qualified as an expert in prosecutorial ethics. Grant Grossberger, Aaron Ordway, John Suthers, qualified as an expert in prosecutorial ethics. Tom Deluxe, Tilo Violta, qualified as an expert in forensic video analysis. Crystal Keem, Margio Sousa, Stephanie Courtney, Matthew Durkin, Tom Raines, Michael King, and the respondent. The hearing board also watched the videotape deposition of Sean Rice. So that is, they have exhibits. Yes, he is. You have to make sure that no one takes a flying leap at me when they finally get, consequences. You may use, all your powers. The respondent was admitted to practice law in Colorado on October 29th, 2012. So it is not like she is a new lawyer. She is not a baby lawyer. She didn't, just maybe forget to take notes in the ethics class. This woman has been practicing law for a while, and she was elected to, serve as the DA. So this is not a dumb woman. This is not a woman unaware of consequences of her actions, which I think makes what she did absolutely more egregious and absolutely heartbreaking for that little boy who is never going to get justice. And I know I keep harping on that, but it freaking ticks me off to no end. It frosts my flakes. It burns my biscuits. It makes me want to curse, but I'm trying to be a better person sometimes. She is thus subject to the jurisdiction of the Colorado Supreme Court and Hearing Board in this disciplinary hearing. Morphew case finding of facts. And this is where they kind of go over an overview. Again, I do like reading these because it's a good way to get kind of a sort of, mile up view of what this case is about before we get into the nitty gritty of actually looking at the investigation and articles and hearings and things like that. You get to have a sort of unbiased kind of, these are the facts, bare bones kind of thing. The respondent grew up in Davenport, Iowa. After receiving an associate's degree in criminal justice, she moved to Colorado in 1989 and worked as a truck driver. With the eyeliner, I can believe it. In 1993, she obtained a bachelor's degree at Metro State University in criminal justice, and later she served as a police officer for several years, first in Avarda and then in Blackhawk. Before starting her family, respondent returned to driving semis, which paid more, which she adjudged was less dangerous. She had two boys who are now grown. Eventually, she attended the University of Denver's master's degree program in public administration with an emphasis on DV prevention, an issue personal to her, having been a victim of DV. In autumn of 2006, she enrolled at the University of Denver Law School in the part-time evening program with the goal of working as a prosecutor, and she graduated from law school in May 2010. The respondent was admitted to practice law in Colorado in 2012. She has worked as a prosecutor for most of her legal career in municipal, county, and district courts. In 2017, she briefly worked in a private practice before accepting employment as a hearing officer for the Colorado Department of Revenue. She worked for the IRS. We should have known she was evil. I'm just saying. She left that position in 2020 to campaign for the position of District Attorney, or DA, for the 11th Judicial District, which encompasses Fremont, Chaffee, Park, and Custer County. She testified that she ran in part on a platform of prioritizing cold cases. She won the election and was sworn in January 11th, 2021. The respondent recounted that on assuming the role of district attorney, she discovered that the office was buried in a backlog of case, hampered by several prosecutorial vacancy, and cash-strapped as the county commissioners refused to allocate adequate funds. She defeated Tom Deluxe in the primary and Caitlin Turner in the general election. Now, it does make me giggle a little bit that they called in her, her opponent to give testimony in this, they are giving him a total opportunity to take a fantastic dump on her character, and I am here for it. I wish these things were videotaped because I can only imagine the side eye that was delivered from Mr. Deluxe after he lost in the primary. I would have been here for it with popcorn. She also mentioned, however, that her office held a fund balance of $540,000, which served as a cushion to balance overspending in the budget and cover expenses associated with prosecuting particularly large cases. So keep in mind, she did have a budget. She could have hired people. Yes, it would have, taken away from that rainy day fund in case, things went over, but she had money that she could access. She had funds that she could allocate, even if the county commissioners said, no, not right now. We cannot afford that. They did have a fund. Since January 2021, the respondent has served as the elected district attorney for the 11th Judicial District. As elected district attorney, her deputies operate through her authority to prosecute cases in the 11th district. And her name appears on every filing her deputies submit to court in the district. She's also responsible for overseeing all administrative aspects of the office, including budgeting, hiring, communicating with other county commissioners, and directing allocation of technology and other resources. Soon after the respondent won the election, she hired lawyer Jeffrey Lindsay to fill the position of senior deputy district attorney. Lindsay was a career prosecutor, having spent more than 2 decades prosecuting serious crimes, including homicide, in various Colorado jurisdictions. Lindsay initially staffed the Fremont County docket. Respondent reassigned him to the Chaffee County felony docket in the spring of 2021. So these are just stipulated facts. All of these footnotes on this page, along with exhibits that you can look out for if you so choose. I don't believe that they included the exhibits. I have not gone through all of this, mainly because I like to learn with you guys. Around this time, the respondent won the election. She began corresponding with Mike King, the host of a YouTube channel, Profiling Evil, a publicly viewable show and comment forum. King named his channel, quote unquote, Profiling Evil, to signify that the show's purpose was to expose predatory behaviors and educate people about how predators select victims. King testified that he had reached out to the respondent, hailing her election. She responded, thanking him for his support and sharing her vision for the office. Both testified that they built a friendly relationship over text and email, discussing law enforcement topics, but also personal matters like the sorrow of a parent's aging and passing away. Soon after she took office, she was twice featured on King's show. After the respondent's appearance on King's show on May 3rd, 2021, King texted the respondent thanking her for the trust she placed in him. Well, I mean, getting in bed with a YouTuber as prosecutor, it's an interesting idea. I don't know why more people don't do it. Oh, maybe because it's freaking unethical as heck. And even I, as a third-party intervener, knows that. Barry Morphew's investigation and arrest. On May 10th, 2020, Suzanne Morphew, a citizen of Chaffee County, went missing. For almost a year, several law enforcement agencies investigated Suzanne Morphew's disappearance, including Chaffee County Sheriff's Office, the Colorado Bureau of Investigation, or CBI, and the Federal Bureau of Investigation, the FBI. Her disappearance and the resulting investigation garnered significant media attention. The respondent was aware the investigation into Suzanne Morphew's disappearance was a factor or a reality before she was elected to become the district attorney. So she knew this was going to be coming down the pipeline. She knew she probably should allocate, funds, or maybe be thinking about that. Or at least I would, because I, like I said, am too type A to function. Respondent testified that within weeks of taking office, she discussed the Morphew investigation with John Spetz, the elected sheriff of Chaffee County. She then assigned Lindsay to the Morphew investigation by virtue of his assignment as the felony prosecutor in Chaffee County. Now, this is, I think, where the train starts to go off the rails. She should have taken someone who solely did investigations. You already have a gentleman that's full of felony prosecutions for Chaffee County, but now he also has to look up this case, which is going to be large. It involves different agencies. I mean, this is going to be a hell of a case. And she basically told, this district attorney underling, like, I'm gonna give you a new job, no raise, but you get a new title. According to the respondent, she did not have the requisite experience to try the case herself, and instead she took on county court docket duties in Fremont County. Well, I'm glad we elected you when you don't have the ability to do your job. I mean, again, I understand that there is going to be, a settling period. It doesn't seem like she's held administrative positions. But why the hell would you elect someone who has no idea how to run an administrative, or how to have those administrative skills when that will essentially be their job? People, pay attention to what elected people tell you and what they do not have experience for. In March 2021, Lindsay started talking to Commander Alex Walker, chief investigator for the 11th Judicial District Attorney's Office. Lindsay quickly realized the investigation was enormous. According to the respondent, Sheriff Spetz invited her, Lindsay, and Salida in spring 2021 for a 2-day presentation about the Morphew investigation. She and Lindsay attended and asked questions. Then, around the end of April 2021, Walker sent Lindsay a 129-page arrest affidavit for Barry Morphew. That will probably be the next thing we cover. I tend to look at more of the court documents than sort of the media kind of look at what things do, just because I like the organization of the court documents. They seem to lay out exactly what the police think or did think in the probable cause affidavit. The respondent testified that she and Lindsay were actively involved in discussions with Walker about the affidavit's iterative drafts. On March 5th, 2021, Walker submitted to the 11th, District Chief Judge Patrick Murphy the affidavit for arrest warrant for Barry Morphew, which sought to arrest Barry Morphew for Suzanne Morphew's murder. A no bond hold was requested due to the first-degree murder charge. Judge Murphy found probable cause to arrest Barry Morphew, who was arrested on May 5th, 2021. After Barry Morphew's arrest, respondent attended a press conference alongside Sheriff Spetz in the afternoon of May 5th, 2021. Respondent testified that she was exhausted but did not want to be at the press conference and did not want to answer questions. Ma'am, that is, again, kind of your job. Current president aside, and this is not political, but, we had FDR who walked, with crutches after, Pearl Harbor. We had W have at least a semi-coherent talk at 9/11. They could have been tired. They could have been, exhausted and not wanting to do this, but they still did it because it's called being an adult. And just because you're tired and you don't want to answer questions doesn't mean you can't, you can just call off. Is this woman a millennial in spirit? The sheriff, however, interjected and told her that her ass had to be there. The respondent recalled being briefed beforehand for 2 hours by a public relations officer about responding to press questions. At the conference, Sheriff Spetzel deflected several questions and directed them to the respondent. According to the respondent, she knew she had to choose her words carefully and stressed that Barry Morphew was presumed innocent. At one point, a journalist asked her whether Barry Morphew was cooperating with the investigation and whether he was questioned about the location of his body's wife. When Sheriff Spetz gestured for the respondent to respond, she answered, quote, Barry Morphew was taken into custody, and when asked questions, he said he wanted a lawyer and all questions ended. Morphew first appeared in court on May 6, 2021 to hear the charges against him. The arrest warrant remained suppressed during that appearance. After that, Lindsay took the role of lead counsel for the Morphew case. Respondent assigned Deputy District Attorney Aaron Pembleton to the Morphew case to assist Lindsay. Respondent spoke to Lindsay on a weekly basis about the case's status. On May 18, 2021, Lindsay filed a complaint and information outlining the charges against Barry Morphew, which included first-degree murder, a Class 1 felony, tampering with a deceased human body, a Class 3 felony, tampering with physical evidence, a Class 6 felony, possession of a dangerous weapon, a Class 5 felony, attempting to influence a public servant, also a felony, but we don't know what class. Yeah, that should never have been said. It just sort of said he's been taken in for questioning. Him getting a lawyer for people who are not indoctrinated or baptized into the legal community or the adjacent, lay community, people can see that as an absolute admission of guilt when it's just being smart. So with that knowledge of how people could interpret that, she went ahead and did it anyway, which again is beyond frustrating. Discovery difficulties. During the Morphew investigation, the sheriff's office acted as a central clearinghouse for information collected by all law enforcement agencies. After Barry Morphew's arrest, the sheriff's office dumped a 10-terabyte external hard drive of discovery, including scores of videos and other digital-based discovery, on the district attorney's office. Crystal Kem, an administrative assistant with the 11th Judicial District Attorney's Office, testified that discovery production, the most massive she had ever seen, was not usefully organized, merely slotted into digital folders labeled according to the agency that generated the material. Wait a minute. This is hurting my type A brain. So you didn't, organize these in like all videos from, such and such a day, and then have a side note as to where and who produced this video, FBI, Colorado Bureau of Investigation, Sheriff's Office. No, you just had big old folders that said FBI, CBI, and locals. No wonder you guys could not find not a damn thing. Who the hell is your organizational label maker? Because I am willing, although I do get super pedantic with it, so I might not be a good person after all. Kem explained that it was extremely irregular for the sheriff's office to send discovery on an external hard drive. Usually, she said that the sheriff's office organizes discovery, labels it, and uploads it into Action, a proprietary in-house statewide case management system for Colorado prosecutors. Respondent agreed, calling the production an quote-unquote anomaly and faulting the sheriff's office for failing to mention the size of the discovery cache. Had she known, she said, she could have delayed filing charges or put resources in place beforehand to process the materials. Hey, ma'am, when you got this big-ass hard drive, you didn't think, well, gosh, I should probably get some help up in here. You're like, nah, it'll be fine. Put it in file folders labeled FBI, CIA, and whatever else. I mean, what is going on? This boggles my mind. I can't imagine anyone being so bad at their job. The prosecution team, including the respondent, was aware that under criminal procedure 16, initial discovery was due within 21 days of them filing charges. In addition, Barry Morphew's counsel filed a discovery demand on May 17, 2021. To timely get materials to the defense, Lindsay instructed Kem to copy the information onto an external hard drive, bypassing the usual process of Bates labeling the material before producing it to the defense. Lindsay then directed Aaron Ordway, an investigator for the office, to drive to Denver to hand deliver the hard drive. So again, they handed over this stuff slotted into different agency folders with not one sense of direction. There were no labels put on there, saying, hey, this is from such and such a date. This is... Daily, law enforcement agencies sent new batches of discovery to the sheriff's office, which in turn forwarded the material to the district attorney's office. Kem worked long hours uploading the material to Action so that the district attorney's office could Bates label it. Kem then tried to run the new information through eDiscovery, Colorado prosecutors' electronic discovery portal that integrates with Action and uploads information onto a standard format the defense counsel can access. But eDiscovery got bogged down due to bandwidth issues, Kem said, which prevented her from efficiently uploading material. Judge Murphy, who was presiding over the Morphew case, held hearings to address discovery issues on May 27, 2021. Lindsay and Pembleton attended in person, and the respondent appeared virtually. On June 3rd, 2021, Judge Murphy issued an order ruling on the defense request to compel discovery, ordering that, quote, any electronic communications created or received by law enforcement officers related to this case must be disclosed to the defense if they are material to the prosecution of the case or if they contain evidence that would in any way be favorable to the defense. So they are basically telling her, like, give us the discovery. We want the internal chats because we have seen Canton, Massachusetts. We want to make sure y'all aren't, calling Barry a dingleberry in the group chat. But basically, that's kind of what went on. The defense is like, give us our discovery. Also on the 3rd of June, 2021, Judge Murphy issued and the respondent received an order regarding the defense team's motion to limit pretrial publicity, quote, without suggesting that there were any violations of general ethical principles. So the defense wasn't saying, like, y'all done effed up already. The defense was simply saying this is a big case and be very, very careful what you say about it because you could prejudice or nuke this entire case from space. Again, the defense was just kind of like, hey, just to remind you, don't step on any, rakes and hit yourself on the head. Judge Murphy set forth guidance in all forms of extrajudicial statements about the Morphew case by reciting and incorporating Order Rule of Professional Conduct 3.6 and 3.8, as well as the relevant comments. So he basically said, yeah, y'all just don't FA, don't FO. You are not going to find out if you just follow the rules given to you in the employee handbook by Sheila from HR. And no, I did not get myself a tumbler, but I was able to finish all the dishes and start a load of laundry. So I feel like I am functioning as a human adult right now in the break. As the prosecution struggled to efficiently manage discovery requirements, the defense filed a motion for discovery sanctions on June 24th. So they asked for, can we please freaking get the discovery on May 27th? By June 24th, they still had not gotten the discovery. It requested a contempt citation relating to discovery issues on July 6, 2021. So again, they had to cite this on July 6th. They still hadn't gotten all of the information. And it filed another motion for sanctions on July 8th, 2021. On July 22nd, so again, he was arrested so he was arrested May 5th, and it is now, I should take notes. It is now July 22nd, so this is ridiculous. Judge Murphy ruled that the prosecution had committed a discovery violation by failing to timely provide cell phone data and other electronic devices to the defense. Judge Murphy did not conclude that the prosecution failures were willful and declined to enter sanctions. Now, she is not oblivious to the fact that her team is struggling. In fact, if she's a good job, she sees it, she gets more people, and she digs into the rainy day fund. But apparently she was too busy figuring out what to say on YouTube. Allegedly, this is my speculation. She was also aware that if the court finds a pattern of discovery violations, the The presiding judge has wide discretion to impose sanctions, which can involve excluding witnesses or evidence, reducing or dismissing charges, or the nuclear option of dismissing the case. So she is aware of all of these consequences if her team continues to, well, be terrible. Welcome, Annabelle. I hope you enjoy this. Now, at the disciplinary hearing, Lindsay testified that the respondent did not make efforts at that point to rectify the discovery issues in her office. But respondent insisted the part of Judge Murphy's ruling hinged on the prosecution's failure to provide a mirror image of a cell phone, which the prosecution had not regularly provided in criminal cases before that point, and a recording pulled from a spy pen that Suzanne Morphew allegedly surreptitiously placed in the home. I didn't know she had a spy pen. I'm learning all the new things, which prosecution provided, but the defense alleged was inaudible. According to the respondent, these discovery violations occurred only because the prosecution had to go to the back of the line in asking CBI technicians to process these defense requests, leading to a lag in production that overstepped the discovery deadline. Notice in all of these paragraphs that the DA takes 0.000 responsibility for any of this. She's like, it was the CBI. And honestly, we have never had to flip an image and we only do pinch to zoom. I mean, ma'am. Now, during this time, the respondent continued to communicate with YouTuber King. She testified that their private correspondence was not meant to be published. Ma'am, you are talking to a YouTuber. Depending on how scrupulous they are, do not assume that your DMs are private. I would never do that. I think it crosses a line, but don't assume that everyone has the same sort of line in the sand that you do. Okay, I make a caveat to that. Only if you come after my kiddos or try to do something incredibly heinous, only then, and I would have to really think about it, would I ever, release DMs, because I just think that's a cruddy thing to do. But I don't judge other people that do it. Maybe the other person had been a butthole. I try to look at dingleberry cases on a case-by-case basis. Now, she said that King honored that understanding and never published their exchanges. On May 15th, 2021, King requested information about a short rifle some speculated that Barry Morphew used to unalive Suzanne Morphew. The respondent responded to King by text, quote, I'll see what I can do only because it's you, Mike. Well, I mean, it does help when you just can talk to the prosecutor and get all the inside information. He must feel like one of those acolyte shills. Like, I got to be in the behind the scenes, but it was for the acolyte. But I got to be behind the scenes. No, it's just wrong. Again, in my opinion, look, as I say, I am a deeply unserious person, but when it comes to these cases, I tell you guys when I am speculating. I tell you guys when this is just my headcanon. I don't want you to get wrong information from me, and I wish all other YouTubers were as scrupulous. And for the most part, the people I hang out with are very scrupulous. Megan Fox does all of her research. She has the CVS receipts, Tug, Nicholas Starro, MLS Law. I mean, there are actual lawyers who come and have their ish together, and there are true crimers and lay tubers that do too. But a lot of them, some people don't, and it bothers me when they give out these crazy theories and things like that and really whip up their audience with not a lot of information. I feel like that's really how we get denigrated as true crimers, because you have the people that are out there that, want to sell autopsy photos in their Patreon just because they can get access to them through a Freedom of Information Act. That is gross on a human personal level and on a YouTube level. Anywho, I will get off my soapbox. I'm just saying. Now, There we go. Via text, King also asked the prosecutor whether Barry Morphew strangled Suzanne in the hot tub. The respondent replied, quote, "We know it wasn't bloody. The hot tub was drained with crust around the drain areas, indicating it had not been used in a long time, but keep spinning ideas in your brain." Well, I'm glad we're asking YouTube to come up with theories in the case. To be fair, I think some YouTubers could probably solve the case better, allegedly. And King messaged about Suzanne Morphew's car keys, and the respondent replied with, quote, "We think she always left her purse in her car." Later, in mid-June 2021, respondent texted King, sending him an article titled, quote, "News organizations asked judge to reconsider his decision to seal Barry Morphew's arrest affidavit." King replied that he would create something tonight and put it out in the morning. Ew. Just no, again, this is all wrong. King also expressed enthusiasm that Judge Murphy was being challenged, and the respondent was not opposed to publicly releasing the affidavit. Later that summer, King texted, "I have a new video coming on Barry, and I laud you, you good." Respondent replied, "I'm great, thanks, we got him, no worries." Ma'am, you are not a teenage girl. You are not supposed to be fangirling over a YouTuber and giving him inside baseball information. Or at least I think that's how you talk about inside baseball. Look, I am not a sports ball person. I will be very honest with you. Well, she did finally notice that they needed to expand the prosecution team, probably because, Lindsay, the attorney that she just shoved all this crap on, probably was threatening to quit. This is my headcanon. According to Lindsay, he felt taxed and overwhelmed by the summer of 2021. He was handling a full-time felony docket in Chaffee County, as well as litigating the Morphew case, one of the biggest, most ungainly cases he had ever prosecuted. He testified that he viewed the sources available for him as pretty paltry and frequently requested that the respondent help, including for at least another full-time lawyer on the Morphew case. The respondent was not responsive to his emails. Well, she sure as hell could get back to King and YouTube. She was like, "LOL, love you lots, YOLO." I mean, for flip's sake, people, we hired a freaking Taylor Swift to be a DA. "Fangirl, love my cats, YOLO." How about you pay attention to the job you are supposed to be doing and not chase after YouTubers? And we will be watching, and no hate on this particular creator. I don't intend to start drama, but we might watch snippets of her interviews on that particular subject and her egregious extrajudicial statements that let two potential child unalivers, baby unalivers, out because she's so prejudiced the case. Yes, again, I will forever be petty about that. My moral high horse may be a mini pony, but it still has legs, people. He recounted that she was not easy to find in person. In addition to not responding to his emails promptly or efficiently, he reported that she did not help in any way with discovery or motions, though he expected as the elected district attorney, she would be involved in every aspect of this high-profile case. Respondent disagreed with Lindsay's characterization. She described her role as counseling, advising, and staying abreast of developments. Well, ma'am, you seem to be a part of the itty-bitty, booby committee as far as staying abreastment. You might need an enlargement to stay abreast. Ma'am. She testified that until the late summer 2021, Lindsay never mentioned he needed additional assistance. No, you probably just didn't read his email, ma'am. Nor did she recall Lindsay requesting a full-time lawyer on the Morphew case. Ma'am. Now, I don't want to be a bit pedantic, but you are in a management position. You are supposed to be able to take disparate facts of, this is a big as shit case. I put one dude who still has a full docket on it and like a baby lawyer and, administrative assistant on a case that has 10 terabytes a freaking discovery and growing every day. But sure, he never asked for help, and you never noticed that he needed help. Nevertheless, at the beginning in June 2021, respondent began regularly asking Tom Raines, executive director of Colorado's District Attorney Council, or CDAC, for support. CDAC, a statewide organization representing all 22 Colorado District Attorney's Office, provides prosecution-related services as part of that mission. MLS, it is, one second. It is a recommendation to disbar, and it is against Linda Stanley, the elected DA that presided over the disastrous non-case against Barry Morphew. So it is, oh, Christine, I am so happy that you are back home, and I hope you get some rest and feel better, and everything went really well. So MLS yesterday, we went through the complaint. I guess Colorado has kind of steps to getting disbarred. So we went over the complaint that was made by the lawyers that heard, all of the shenanigans she did. So this is the judge's response. And MLS, it is 83 pages long. It's never good to get an order that's 83 pages long, is it? Because I'm guessing, that's a bad thing. Let's see. Oh, I see what I did. 1 second. Sorry for the scrolling. Not only that, MLS law, but she gave privileged information, inside baseball information, to a YouTuber, kept him abreast of the entire case as it was being investigated, and even went on his show to give her unguarded thoughts. Now, the kicker of this, MLS, is that when her comments and her, as it is the internet, when her comments received pushback, she decided to use her own name to respond back like a reply guy, getting paragraphs in to prove her point. But again, using her own real name, not even a VPN. What the hell? And guys, check out MLS God of Laws network. He is an actual lawful law lawyer. He can answer all your questions versus me just making things up in my head or simply telling you, I have no idea what I'm doing. I'm just a mom who likes to read a lot. And oh my gosh, footnotes. You know me. Gotta love me my footnotes. What? Great success. Breaking news. Third attempt against Trump in 2 months. Police have found explosives in a parked car near Trump's rally in New York City. Oh my gosh. I hope that I'm glad that they caught this. Again, I try not to get political unless I'm on my political channel, which I sort of have let go by the wayside with back to school starting. I always intend to have a lot more time than I actually do. I have optimistic time management issues. I'm like, yeah, I can add like 4 more things. Come over here. We're going to have fun. And then I realize I've bitten more off than I can chew. So I will be getting back to that. But please, Lord, could we just not with, civil war? I mean, could we just not? Any hoozle. So after she got done with, having the talk with the inside baseball texting behind the scene with the YouTube channel, she finally decided to notice that maybe when you have a case with 3 different agencies involved and an initial dump of discovery digital wise of 10 terabytes, you might need more than 1 lawyer, 1 baby lawyer, and a administrative assistant. Not that they all weren't working hard, but the head lawyer in charge of this case still had a full docket for a county full of felonies. I mean, this is basic human resources and management kind of stuff, and she failed spectacularly. Now, she did contact the CDAC. Raines often taps his network in more resource-rich judicial districts for volunteers to assist in cases with rural jurisdictions. Statewide, this was a very challenging period to recruit and retain prosecutors. However, and Raines was unable to find any elected district attorney that could spare lawyers for secondment to the 11th district. While Lindsay began calling his own contacts, something that he had never before had to do as a line deputy, he reached out to Michael Doherty, the elected district attorney in the 20th Judicial District, and Daniel Rubenstein, the elected district attorney in the 21st District. Neither could help. Lindsay also called Mark Hurlburt, former elected district attorney in the 5th District. And MLS, oh my God, the names in here. We have Wiener, we have Hurlburt, and we have Grossberger. I cannot with these names, but it's all crazy. Though Hurlburt was living in Summit County, he began working for the 11th District. Look, y'all, judicial is a hard word for me to say. I will be avoiding it if possible. Since before the Morphew case was filed, handling correctional facility homicide cases on contract. In June 2021, Hurlburt agreed to join the prosecution team as a deputy district attorney. Respondent assigned Hurlburt to the Morphew case. In August 21, Lindsay contacted Daniel Edwards, a former assistant attorney general, deputy district attorney, and public defender to assist the prosecution in answering and filing motions. And all of these footnotes are just stipulated facts. If I come across a footnote that is goes beyond we stipulated things, I will let you know, because y'all know I love my footnotes. It's a weird thing. I never claimed I was normal. So Lindsay said that he was, quote unquote, desperate for help and literally begged the respondent, the district attorney, to bring Edwards on. Edwards, whom witnesses uniformly praise as a giant in the Colorado prosecution community, agreed to join the team on the understanding that he would continue to live and work in Denver in the metro area. Edwards was hired as a motions attorney. Others on the team were to provide him with facts of the case, and he would then supply the law and argument in draft motions and responses. Though the respondent provided Edwards a laptop intending that he would have access to discovery, Edwards testified that he was not able to log into Action and never had access to the facts of the case. The combined preliminary hearing / proof evident presumption great hearing in the Morphew case was held on August 9th through the 10th and August 24th through the 25th, 2021. This PH or PEPG hearing was meant to assess whether the prosecution had demonstrated probable cause for the charges against Barry Morphew and whether, for purposes of denying bail, the prosecution had shown proof against him was evident and presumption was great. To prepare for this hearing, Lindsay requested and the respondent provided coverage of the Chaffee County felony docket for a full week. In that time, Lindsay organized all the exhibits, prepared all of the witnesses, many of whom he anticipated would be named as experts. Keep that in mind. The experts is where this case went full FUBAR into what in the Walmart am I looking at here? And Lindsay's opinion was that this case would be all about the experts. Try to remember at this time, they hadn't found Suzanne Morphew's body. So they were going on the presumption of her death based on circumstantial evidence. But they were going to need, experts to say it is more likely, beyond a reasonable doubt that he did it, even though they didn't have a body. We have all of this disparate evidence. You had to get the IT goatee cell phone guy in there to say he was right here and he had his cell phone on. And I found him even though he was using airport mode. Things like that. Lindsay handled most of the hearing, but Hurlburt did the direct examination of a few of the witnesses, and the respondent, the elected DA, examined 2 witnesses, including Walker, who had left the DA's office earlier in June 2021 to work for the Chaffee County Sheriff's Office. Lindsay asked both of the respondents' witnesses to write out the questions that the respondent should ask them on direct examination. This woman needs some note. This woman needed notes. She's like, is it fair to assume that when you woke up, you were alive? I mean, where is Lolly for some coaching when you need it? So the judge, having heard all of this evidence at the conclusion of this hearing, reserved ruling until September 17th, 2021. Mid-morning on August 24th, 2021, in the midst of this hearing, YouTuber King texted the respondent, quote, feeling good, end quote. The respondent replied, yes, only because the judge has basically indicated that he's done, and that's good for us, end quote. So these are stipulated facts. They have the receipts. They have the mile-long CVS receipt on these. The same day, King also texted, now the noise I heard Barry Morphew tried to stare you down this morning. The respondent replied, I stared him down. I've tried to every day. Ma'am, you are not a sassy girl boss. Stop. You are not even a good boss in real life. Don't claim the title if you're not going to do the work. Respondents' media appearances. Because, of course, she wanted all the fame for reasons I don't understand. The respondent and King agreed to do another profiling evil segment in late August 2021. At the disciplinary hearing, respondent explained that although she received many media requests from several national outlets, including 2020 and Dateline, well, aren't you special? She never agreed to give interviews. She testified, quote, she was not trying to get famous or put herself out there. She noted, however, she made an exemption to her general media approach for King, and she emphasized she appeared on his show to educate people about the criminal justice system. Sure she did. Sure, Jan. You were going to teach us and learn us all the things. On August 29th, 2021, respondent and King text discussing what he should tell his audience about the, DA and the Morphew case. During these communications, King recounted that they agreed to cover topics including the procedural aspects of criminal cases, including the PG hearing. The respondent recalled that she and King discussed the parameters of the show extensively, and she warned them that she could answer questions only about information in the Morphew case that was in the public record. The respondent testified that before she recorded the segment with King, she conferred with Lindsay and Hurlburt about her participation. In advance of the show, King promoted the segment, advertising the DA's appearance. According to King, some audience members complained about the respondent's return, so she's been on here several times. And even the audience is like, excuse me, I am not a lawyer, but couldn't this jeopardize the case? Asking for a friend, but I'm pretty sure this is not a good thing. And they were like, in true drinker fashion, nah, it'll be fine. So his audience was like, I don't know if this is a good idea. If we actually want Barry Morphew to be, convicted, maybe we shouldn't do legal shenanigans. But nah. When the respondent registered surprise that some of the pre-show comments were quote unquote not good, King offered her the option to cancel. The respondent declined, remarking, quote, I'm not understanding why people are so pissed. And quote, obviously I'm not going to talk about anything that isn't public information. And she concluded the exchange with, I don't ever back down. Well, girl boss your way to disbarment, ma'am. I am here, female empowerment. Don't repeal the 19th. Go win that suffrage. You absolute dingleberry. At the disciplinary hearing, the respondent expounded. She testified that she did not view King's audience as knowledgeable about her ethical constraints as a prosecutor. Were you knowledgeable about your ethical complaint or constraints? Because you seem to be very confused. Do you have ethical dyslexia where you suddenly think that, all things that you do are okay? I mean, you see things in the opposite moral light. I mean, I would use that as a defense, not people on YouTube are stupid. Just throwing it out there. If you Man, it looks like you're going to lose your legal license. You might only have YouTube left. You might not want to call all of us morons when we point out that you're behaving unethically. Just as a friend, fellow future creator, there you go. And she rejected the notion that the power of her office would confer, on her comments an extra measure of credibility in the public eye. Well, maybe in the law and crime and court TV, circles of the internet, but not in the law tube circle of the internet. So, ma'am, nah, some of us are onto your game. On August 30th, 2021, the respondent appeared on King's Profiling Evil YouTube channel. So I am going to look that up. Again, it is not to send any bad drama, upsetness, or anything to Profiling Evil. But I think it's important that we have, our own view of what the hell she said. Again, do not send any drama, any grief to Profiling Evil. I can imagine it would be a great temptation to have a prosecutor in your pocket when there is a giant case that's, affiliated with their office. I wouldn't touch it, but that is everyone's personal choice. So do not send a bunch of bad juju in my name or in anyone else's name to Mr. King and Profiling Evil. These would simply be to see what she said. Now, the King said the show garnered about 23,000 views, and 1,000 of which were in Colorado. During the episode, the respondent explained various procedural concepts, including the meeting of direct and circumstantial evidence, the difference between a preliminary hearing and a grand jury proceeding, what occurs during a PHPEG hearing, and the information that she can ethically discuss, and the doctrine of double jeopardy. The respondent also reported that she intended to add the prosecution team voiced irritation that citizens would question whether she had probable cause to arrest Barry Morphew. She defended her choice of attire during the May 2021 press conference, boasted that she stared down Barry Morphew at the PHPEG hearing, quote, every chance she got, and mentioned Barry's short stature. She's like, yeah, and he's not even 6 foot. Ma'am, are you a 12-year-old girl? I don't care what you're wearing at a case. I don't care if you stared him down and gave him the side eye and, cut a bitch with your eyeliner. I really don't give a crap. What I give a crap about is that you take all the disparate information that you seem unable to organize in your discovery, make a theory, and present it to us. I give 2 craps what you wear. And insisted that, quote, anything out in the public is okay to talk about. After the podcast, the respondent texted King to complain that some, quote unquote, nasty shit was posted about her in the show's chat forum. Welcome to YouTube and the internet, ma'am. We have been shitposty around here for a long time, and trolls are a thing. Grow a thicker skin. She explained to King that her reputation was, quote unquote, priceless to her, and she viewed the comments as, quote, borderline defamation. Ma'am, I'm going to need you to get Black's Law Dictionary because I think your legal education was lacking. During or after, and I'm guessing directly after, the Profiling Evil podcast, the respondent authored comments using her own name and online avatar to respond to various members of the public who posted on Profiling Evil's chat forum. Her comments were extensive. Many demeaned or personally attacked audience members. Yeah, she was a see you next Tuesday, with experts like, quote, sounds like someone needs their blankie, and quote, I refuse to battle or engage in a battle of wits with an unarmed person. Well, I hope you take your sassy attitude to the disbarment line, because seems like you have a great ego. Sometime between the show's airing on August 30th, 2021 and September 30th, 2021, a YouTube member with the username Jean-Luc Basser posted a public comment on profiling evil, responding to the respondents' statements about Morphew. Oh, MLS, we're getting to the part where she responded to people, and here are some experts of her responses. Or her responses with her own name and avatar. Quote, sounds like someone needs their blankie. I refuse to engage in a battle of wits with an unarmed opponent. Now, MLS, I'm going to venture to say that if you are in a capacity of a DA, you probably shouldn't be arguing with internet trolls. I mean, under your official capacity. Call me crazy. Also, maybe don't piss off the entire LawTube true crime community by, being a giant B word, because now that you don't have a law license, you might have to turn to YouTube like Coffin Digger. See, MLS law, I figured that, it's probably against the handbook at some point. Now, this particular user put a response to the respondent's statements about Morphew. Quote, in a preliminary hearing, you are supposed to lay out enough evidence to take the accused to trial. The defense did a great job of debunking a few of the theories. Most reasonable observers of this case aren't even confident that the state laid out enough evidence to take this to trial. How do you expect them to win a case with zero DNA, zero body, with very weak preliminary hearing? Welcome, MT Homestead. If there was some smoking gun, they would have provided more info at the preliminary hearing, causing the judge to actually send it to trial on day 4. Him needing time is not a sign of a very strong case. He has read the holy something affidavit, so apparently he put a cursey word in there already. So if you think there's something special in there, think again. It's best for the state to let this one go for now. Try them in again if you get better evidence. Let me make sure. And these are stipulated facts. So the respondent, while just unable to deal with any sort of direct criticism of her underling's performance, got right back on YouTube under her own name and her own avatar and was clickety-clackety away because this would not stand. She will not back down from a threat. And this is what she said, because she's absolutely stupid. And I do need to look at the case she referenced, because something tells me that the Dante Lewis case was FUBAR too, because they had zero DNA, zero evidence, and zero body, but they indicted him of first-degree murder. So I really do need to look at that case, because what the hell? This is her. Quote, the judge explained why he was going to take time with it. He actually should, because there's a lot of evidence admitted. I'm curious how long you've been a criminal law attorney, since you like to think that you know it. Look this up. Dante Lewis, convicted in Pueblo, Colorado. Quote, that's right next to my jurisdiction. Less than a year ago for first-degree murder. Double exclamation points. Guess what? Double question marks. No DNA, no body, no murder weapon. How the hell did you charge this man? How with no DNA, no body, and no murder weapon did you convict this man? No smoking gun, as you say, but here's the clincher. He was the last person to see Kelsey alive. Ma'am, being the last person to see someone alive means you're unlucky, doesn't automatically mean that you're the unaliver. I don't want to have to introduce you to Nancy Drew and the Hardy Boys, but maybe you need to read some Sherlock Holmes. As we stated and Barry was the last one to see Suzanne alive, as we stated in the prelim. Those items you listed may be important to you, but not for others. Quote, P.S. Dylan Redwine's father was also just recently convicted of first-degree murder in the death of his son. Same scenario. Didn't have any laundry list of items that you think are required for a conviction. I can come up with plenty more. Just let me know. Now, I will tell you an aside about the Dylan Redwine case. There are a couple things that she is leaving out to make it seem like there was not physical evidence in order to, adjudicate the Dylan Redwine case. Daniel Redwine, the father, was convicted because not only was the body found in an area where he was continually going on an ATV up into the mountains, they found his skeletal remains. They found blood 3 years later, still under the floorboards of Daniel Redwine's trailer park home. And they also had the testimony of his older son, who graphically explained the coprophilic pictures and his father in drag while enjoying the contents of adult diapers. I will stop there. There are pictures on the internet. I do not recommend looking at them. I still need therapy and possibly Super Oprah. So we had a lot more information in the Dylan Redwine case than we ever have in the, I don't know the Dante Lewis case, but there was actual concrete, both direct and circumstantial evidence that pointed to what the jury, stated was beyond reasonable doubt that he had been the one to unalive his son. So I hate that she is misrepresenting a case that was so gruesome, that was a father, taking the life of his son because his son found out he was a gross, disgusting weirdo. No offense to anyone who has the kink of coprophilia. I just find it icky. Like, you can do it, just don't tell me unless I ask, and I'm never going to ask. You just keep that deep in your heart, okay, sweetie? Because I don't need to know. I don't want to know. Thank you for your cooperation and not involving me in that particular information dump, pun intended. Now, at the disciplinary hearing, DA Karen, the respondent, justified her post, drawing a, quote, important distinction between her public persona, the elected district attorney, and her own private activities as Linda Stanley. Okay, Two-Face. Who is entitled to defend herself from personal attacks. Again, this is called YouTube. As a person who is probably losing their legal license, you might want to look into social media. This is normal. You do not have to attack yourself from every personal attack. There will be multiple. You have to tell themselves, you just have to ignore them. Grow a thicker skin and good audio if you want to join our group. Well, not our group. You will be on YouTube, so we collectively generally interact, but you're not part of my club, ma'am, ever. She reasoned that in her responsive comments, she was acting as a person, not an elected attorney, as evidenced by the use of her personal picture as opposed to her professional headshot and her personal email rather than her business email. MLS, do you have time to come on? Because I want to ask if lawyers are people too. I'll send you an invite if you have time. If not, I completely understand. It is all the crazy back to school and all the crazy all the time. But I can't imagine that one gets to play dual personalities in order to get away with snarky commenting on a current law case. I could be wrong. So apparently she was a person. I just sent it in Twitter. She was a person. I am not sure if that's legally binding. She also testified that her purpose in responding to Brasier was to correct the record to show that no body homicides could be prosecuted successfully, thus lessening the prejudicial effect of Brasier's comments to her client, the people of the state of Colorado. So wait, ma'am, these are disparate ideas right here in the same two sentences. You're a person, but you're also representing your client, the state of Colorado. That means that you're mixing your personalities, Two-Face. I don't know what happens if you don't flip the coin. I'm pretty sure that you go crazy, but you cannot simultaneously be a person who is protecting your client, because that's not your role right now, according to what you just said out of your mouth hole. You know, when I have more legal acuity and intuitiveness than the DA, really does make me want to run for judge. On September 14th, 2021, soon after her appearance on Profiling Evil, respondent exchanged a Facebook Messenger message with about the Morphew case with Jules Wolfe, creator of True Crime with Jules, which is a podcast available through YouTube and other public platforms. According to the respondent, she learned of statements Wolfe made suggesting that the respondent had not read Barry Morphew's arrest affidavit. The respondent testified that she believed the statement was, quote, super important to correct. Her job as top prosecutor in the 11th Judicial District was to make decisions about probable cause, so she feared the public's perception of her office would be diminished if people thought she had not been involved. What she meant to say is, I want all the credit. I did a good job. Look at me. Look at me. Quote, I did not want incorrect information to be disseminated further. Welcome, welcome. Let me switch this.
Hello.
So I'm guessing having your own personal YouTube bitch fest is probably not appropriate.
You know what I said? She's a boomer that doesn't understand the internet. And like, it's okay to have, yes, attorneys are humans too, right? And there's a whole thing about attorneys don't give up their right to freedom of speech just because they're attorneys and they're licensed and they're supposed to be professional and whatnot. But there's like a general rule is that you don't comment about the cases that you're actually handling. There's a lot of rules about that. So if I wanted to, say, issue a press release on behalf of a client of mine, there's a lot of rules you got to follow with regard to that. And it looks like she's breaking all of them. She's responding to personal attacks and she's like trying to personally defend these things. And all of this is so inappropriate. Hey, Justin.
But Dave, she's a girl boss. Have you thought about how she's a female attorney and she watched Ally McBeal?
That's the thing is that okay, for all I could say about the prosecutor McDonald, who is the Oakland County prosecutor that handled the James and Jennifer Crumley trial, she at least kept everything within the confines of the case itself. She didn't go off on these personal ad hominems and attacks and stuff. I don't think she was right in that position. And the statements that she did make were just about the case, though, right? It wasn't about all this personal stuff. This is a boomer that didn't know what the hell she was getting herself into.
Well, she thought that she could go on the internet and not receive pushback, and she denigrates people that have actually watched the legal process. Yes, it's a call to authority. Yes, you have actually been schooled. You understand the procedural bits. But those of us who have watched trials for a while also have, you know, a stored set of wisdom. We may not term things correctly. It's kind of like that argument, what is prawn? And people generally say, I'll know when I see it. You know,
that's the thing. It's like, you know, something doesn't smell right here is a good sign as an attorney that you should probably kind of walk away. Like there's a general rule, you know, unofficial rule that like if something doesn't smell right, if this seems a bit fishy, you don't want to get mixed up in it. And this, you know, for laymen and everyone else just to look at this and be like, something's not right here. It should be an indicator to this woman that she needs to sit down and shut up.
Yeah, and I didn't get to her truly egregious crime, which really has nothing to do with the Morphew case, but I did want to get your opinion on it since I didn't know how time crunched you are. And look at you, all great, you know, background and everything. I'm so jealous. I'm getting a tree house.
Look at
that's it.
I got all the stuff you sent me. Oh wait, hang on. You sent me this koozie, didn't you? The 1-Up koozie, I think.
No, I sent you the white girl wasted t-shirt and mug
Oh, that's right.
with the white
I
claw.
thought you sent me that stuff. No, I do have that though. I use that mug like every day.
you're in a hearing and they're like, "Sir, is
Yeah.
that White Claw?" And you're like, "No, it's Bailey's with coffee. I have morning booze. What are you
You'll
talking
never-
about, White Claw?"
You'll never know. Zoom is wonderful.
But her most egregious crime, at least to me, and it's not getting a lot of publicity, there was a case that involved two people that were alleged to have ended the life of a 10-month-old baby. This prosecutor took it upon herself to go on television, say they're both guilty as sin. The mother didn't care about the baby. She just wanted her live-in, guy she met off the street to watch this kid, and no one loved this baby. Like, this is all documented. And then she brought up the male defendant's juvenile record that did include some not so great things. I'm not going to defend the male defendant, but she so prejudiced the case by this local news broadcast that they had to drop all charges against these two people that potentially unalived a 10-month-old.
See, that's the thing about DAs in general. And I think one of my comments earlier is that DAs or prosecutors do this all the time. And they need to stop. And more of them need to be disbarred or punished for doing these kind of things. Or even look at Gravely up in Kenosha.
Yeah.
It's this woman's being called out for it, rightfully so. But there are a ton of prosecutors and DAs across this country that are doing the exact same thing and are not being called out for it. So who filed the grievance complaint against her?
Let me look. I love Jedi Jess. She gets me all of my stuff because I am dead awful at just about everything technical.
But kudos to whoever did it, and then kudos to the Bar Association, whoever that's following up with it, because a lot of times these go nowhere. Nobody files it. People that are in the know are too afraid to do it. And, you have to put your contact information out there. So when you do it, so like if I file the bar grievance against an attorney, they're going to know that it was me that did it.
So I guess the complainant was the people of the state of Colorado. All of these were witnesses. So what I gathered from the filing that I've read so far is that Colorado has kind of two attorneys or two judges that will look at the complaint or look at the allegations of misconduct.
Yeah.
They're kind of the gatekeepers. So they'll say yes or no, and then it goes up to the Supreme Court. So it looked like they got complaints, they adjudicated them in their opinion to be credible and move them up to a disciplinary hearing. And then this is the judge. What I was reading now is the judge's opinion of all of this.
Okay. Yeah. So like in Michigan, if someone happens to file a grievance against me, it'll be reviewed by the state bar's grievance council. And then they could make a recommendation. And then it would be in Michigan, it would be the state bar versus me, but it would still be in the court system at that point. But it won't be that particular person that filed the grievance. It wouldn't be that person against me. It would be the state bar after looking at their grievance. So that's why I was just curious who brought this to light.
Now, I did want to ask you a question while you're here.
I kind of want to look at true crime with Jez. Wait, what was that?
With Jules?
With Jules? Is that what it was?
Yeah, I'm going to have to look at Profiling Evil and Jules to see what kind of true crimers they are. Not for, to send any drama there, but to kind of see how she conducted herself during these media interactions. But slow walking of discovery, is this a systematic problem, or is this, it seems like in the Delphi case, in the Zachariah Anderson case, in many high profile cases, there seems to be a slow walk or inability to get discovery at a timely manner. Is this a systematic or system-wide thing, or is it just for high profile cases? So we notice more of a correlation.
I think it's more of a issue with high profile cases, but also the issue with the volume of discovery in these high profile cases. For example, like I've never really run into like discovery being released last minute or way beyond the deadline
Okay.
in any of the criminal cases that I've dealt with. I have dealt with cases where the discovery is a minimal and I have no idea why I don't have it yet. Right. Like I
Yeah.
would really like copies of police reports, witness statements, photographs, and videos before the preliminary examination is scheduled. That's 2 weeks out. It's not that much. You should be able to get that to me. And I get it like 2 days before.
Okay.
It's not as an issue because I'm still getting it fairly early in the case and it's a minimal amount of documents. But if you were to say, if you had, tons and tons of video, then or documents and stuff like that, and you get it 2 days before, then it's a different story. So I think it's just the bigger issue is because these high publicity cases tend to have a lot more discovery associated with it.
Okay.
I don't know. I don't see it as being a regular thing, although they do pull shenanigans even in the smaller cases. Like I had a case that involved alleged child abuse and domestic assault. And at the last minute, like 2 weeks before trial, the prosecutor said, well, we want to introduce this, my client's entire criminal record. And I had to scramble and file a motion last minute to say, no, you can't, judge. And then the judge excluded it all properly. And that's great. But why is the state even trying to do that? Why are they trying to do it last minute? First of all, they know that they violated the timeline and disclosing that. They know that they can't get it in because, you don't, convict people on their entire criminal history. So,
Well, yeah.
but they're doing it because if it's not challenged, then they can get it in. And it's that sort of stuff that they do a lot of.
Well, I did notice, like, when I did jury duty, although I tried to get out of it. You don't understand, Dave. I verbatim gave the response, since I have this weird ability to hear things and then repeat them verbatim. So I gave the verbatim response, jury instruction wise, of what reasonable doubt is. And I was like, it is, with the reasoned forethought that a normal person would use in decisions of great import in their life. Because I'm thinking these people have to know I watch trials like it is my job, because I'm supposed to be making it my job. And they stopped. The judge looked at me and they're like, that's the best answer I've ever heard. And I was like, mother effers, I am trying to get out of here. These seats are uncomfortable.
When was this? I'm disappointed in you and trying to get out of jury duty. It is the most fundamental job that we have as American citizens.
I was assuming they were going to. Well, yes, I did. And we adjudicated him not guilty because the state sucked balls in their investigation. Literally, the entire trial, I'm beginning to think state troopers need narcissism or arrogance deflation training, because literally the entire case boiled down to the state trooper was off duty doing security for a hunting ground. It is the first day in Indiana of white-tailed deer hunting season. He is looking for a trespasser on this property. He is only wearing an orange hat, but he is walking around shiftily near another person's property. Now, in his great strategery, he decided to contact none of the surrounding property owners, who all but one hunt on Deer Day, to explain that he's going to be sneaking around like a freaking trespasser, which has been a problem in the past. He goes out, and a fellow gentleman who is hunting or in his deer blind nearby sees him kind of like wandering around, not paying attention. So he decides to fire a warning shot into the berm of his pond, which is his target range. It is 90 degrees opposite of the state trooper, who he doesn't know is a state trooper at this time.
Okay.
Now, the state trooper...
Why is the state trooper on private property?
Because he had a arrangement with the property owner to not only lease cattle land, but be the security guard, because they were having trespassers and problems with that. So he He had taken on this role, but decided not to contact any of the property owners around him, even knowing that most of them would be carrying force multipliers and trying to get them a deer. Now, as the trooper is crouched down in fear for his life,
Yeah, they're always in fear for their life.
the guy in the deer hunt, now this is his explanation. I don't know if he just thought that this was a random asshole walking around property and decided to be a smartass, but the state trooper kind of he lets out a scary clown laugh. I shit you not. I hear the details of this case and I was like, this is a Mo case. So he lets out a scary deer laugh because, according to the defendant, the scary clown laugh that he learned in the haunted insane asylum in Indiana for his job several years ago does not scare the deer, but his voice does.
What?
Look, this is his story. I am just telling it. Now, the state trooper has shart his pants at this point because he's afraid of an evil clown. So after a couple seconds of no more firing, he gets up and he decides to be a smartass. And he's like, did you get your deer? Now, the defendant should probably not have responded this way, but it was fucking hilarious. Excuse my French. He said, no, I'm not hunting deer. I'm hunting dumbasses. And that's when the man decided to explain that there is a problem. I am a state trooper. Dave, I shit you not. His name was Trooper such and such, Superman such and such.
His middle
And
name is Superman?
No, that's his moniker. That's his nickname.
Oh, that's his nickname.
I swear to God, he said in testimony, I even have it in my notes, which I'm upset that they shredded because I wanted all of them. He even said, and I quote, Superman never takes off his cape. I can never take off my state trooper identity. I'm always situationally aware. I was like, that's why you are wearing only an orange hat on the first day of deer season, Superman?
Yeah, this deserved to be an acquittal just based off of what you're telling me. That's nonsense.
They had him in jail or in legal binding stuff for 2 years. They were going for a felony intimidation and reckless use of a firearm, which would have been cool if they had actually looked where the, freedom seed had gone, because it was freshly snowing. The defendant offered the DNR officer who came to investigate a metal detector in order to look around the area that the trooper was and then go see where the bullet actually landed. Well, they were too busy. It was deer season. We have to make sure drunks with guns don't shoot people instead of deer and or fight each other.
They have no evidence that he even shot in that direction, except the defendant's own testimony, which is that I didn't shoot in that direction. The defendant was lawfully on the land that he was supposed to be on.
Yeah.
Yeah, this is all BS. I mean, I'm assuming like there's no other issues, like he's within 100 yards of a structure.
No.
Yeah, so this is all BS.
So the biggest BS is that in the recorded statement of the interview, now granted they recorded from their pockets in their phone, and somehow the DNR agent didn't record his interview with the state trooper. I know you're shocked.
Right.
And he was handpicked by the state trooper to come out and investigate. The DNR officer, quote, said, I'm sorry, this time you just happened to catch a state trooper. You might get in trouble with this. He's like, I'm sorry, you just happened to mouth off to a state trooper. And I was like, I'm done. I don't need to take any more notes. Can we be done now? Can I get my $80 for being here?
Now, let me ask you this. How did you feel about, I know we're completely derailing your stream, but how did you feel about the jury process? When you guys got back there, did you do a straw poll? And then was there like a lot of people he's guilty?
Dave, they freaking made me the not for person because apparently it's the premier juror, because I take compulsive notes to stay awake and stay paying attention since I have ADHD. So I had 16 pages of notes, full legal pad for a 3-hour trial, because that 3 p.m. hour, I was like, Lord help me. I need to stay awake.
This was a one-day trial though, right?
Yeah. It was a one day. Well, what I will say is that having knowledge of trials kind of helped, and I think that's why they made me premier juror, because as soon as we got back in, now this is a new thing in Indiana. I don't know if they do this in Michigan, but we were allowed to talk about the case during the breaks, but not deliberate.
Huh. That's interesting.
I
They
was
don't do
like,
that in Michigan.
no, I was like, this is not allowed. This is not allowed. It's like when I was a young Catholic still practicing and I went to a Presbyterian church and the pastor had a wife and I was like, I don't know if you know this, but God said that's wrong. Like, how did you get married?
But that's cool. So you guys could talk about it. Was there any lesser included, and was there any sort of like idea about maybe compromising?
No. But I had to caution them because there were able to get several hunters, several experienced people with, kind of hunting, because I have no background. I'm like, I have no idea. So it was nice to be able to ask people like, okay, is it typical to just wear a hat when you're hunting and kind of skulk around places? Is that considered hunter safety? But I also had to caution them because some of the hunters were like, this is bullshit. They're trying to take away his guns. I know what they're going to do if if they charge him. And I said, you guys, I hate to be a Debbie Downer, but you cannot discuss, any sort of potential punishment. We're not allowed to take that into consideration. You're going to hear it in jury instructions. I'm just letting you know that, yes, we know, but we're not supposed to consider. So
yeah, that's one of the things, which is interesting because other states allow you to take punishment into consideration, but most Midwestern states don't. But no, I was curious. I want to sit on a jury again. I haven't since I was like 20. And
it was
would be fun.
interesting to see all of the things that I watch on TV, on YouTube kind of happen. I will say I would like to lodge a complaint with the Geneva Convention because the infotainment, you just got jury duty with Troy McClure in it. I showed it on my stream when I was explaining this entire shit show of a case. And I was like, this is absolute torture. This was the part where I realized that I have spontaneous outburst syndrome because of YouTube. So I'm like, stop, pause. What the hell is this? What in the Midwest early 90s are we looking at here? What in the side of ranch is going on in this particular?
Well, I want to commend you for making the right decision on that case, at least from what it sounds like. A lot of people are so quick to convict, and
I felt a little bad for the prosecutor because I kind of was stating, recklessness, has different meanings in both, a legal sense versus a colloquial sense. And this is how I talked to him. I was trying to tell him, like, dude, I am probably not going to side with you. And I said, there is a higher burden in criminal cases. So if you're asking me about recklessness in a civil case, all I'd need to do is 51% believe you. But I need to fully believe beyond a reasonable doubt in a criminal case. I'm like,
you're
dude,
trying
I know
to get
about
off by citing the law. Imagine this. All right. So we want a potential juror who doesn't want to be on, and she's citing the law saying, listen, you got to bend over backwards to convince me of his guilt. And that is a potential way to have the prosecutor strike you. Now, think about how messed up that is, that our system is. If you cite the actual standards, you might get thrown off the jury.
Well, that's what I was expecting because I know so much, but it's not in me to, act stupid when asked a question. I sort of have the, spontaneous, like, you ask me a question, I'm going to recite back to you what I know about it. And then I was like, well, I've blown my cover. My hair is no longer going to work for me. I know about trials. And it wasn't that I wanted to get out of it. I just wanted the lawyers to be aware that I am going to hold you to a very high standard. So if you, I know the rules. I know how you shade things. That's basically what I was telling the state. Like, don't mess with me.
By the way, so when I voir juries, I ask them now if they watch any trials on YouTube, if they watch any true crime, if they watch any of this stuff, and then I dive into that. Like, well, where do you watch it? What platform do you watch it on? Are you watching the actual trials? Are you watching like 48 Hours?
You strike
What do
anyone that says law and crime. You're just like, and we want them off of the jury.
Yeah, exactly. If they're a law and crime fan, then they're out instantly. But no, that's really cool. Yeah, was it?
Yeah, it was interesting, and it was interesting to see how the lawyer explained reasonable doubt to maybe the people not clued in. So she brought up different. The defense attorney brought up different bottle sizes of Tylenol, and she said, "Okay, would you, take this open bottle of Tylenol if you knew that 1 in 25 of these pills had cyanide in it?" And then she went up to a higher one and said, "So, okay, we've got 100 pills in this one. Would you be okay, taking this if you knew one?" And then she went to the like mega Costco, you have chronic pain bottle. So she was explaining
That's
how,
interesting. That's an interesting approach to reasonable doubt.
yeah, because it kind of explained how, and she explained what I thought was really scary was when she asked people, "What would you do if I did nothing?" And so I guess I must have squirmed in my seat. Like, as a defense attorney, I just sat here and let the state do everything. And one guy said, "Well, I would hope you'd prove him innocent." So I raised my hand because I was pissed off at people being dumb. This is why I didn't do well in school. And I said, "No, the burden of proof is on the state. Burden shifting is a big problem. The state has the burden." Again, I am telling the state, you do not want to mess with me. I was like, and then this poor guy who looked kind of like a younger version of the dad from Beetlejuice before we found out he was a creep. That was the state's attorney. He just kept looking at me like, "Believe me, bro. Believe me." And I was like, "Sir, I am voting not guilty as soon as my ass gets in there. You have made me wait till 7 o'clock at this flippin', thing. You have dragged this man through hell for 2 years.
Was he
I am pissed
incarcerated
off
the
at
whole
you."
time?
He wasn't incarcerated, but the backstory to this is the property owner that the state's trooper was working for has the large majority of the properties and the adjoining properties. Either he is going to be buying or he is acquiring. This man has 11 acres that he bought when he was 20. He's not willing to sell.
Oh, so there's like
This
this whole
this
motive kind of thing behind it, or potential
That's what
motive.
it seemed. Now, this is in my head canon. This was not overtly stated, but it did seem coincidental and a little bit dubious that not only the, you know, property manager and the, owner who wants to turn this property into an exclusive game park find a reason to get mad at the one guy in the middle of, these properties that they're wanting to.
That
It
could
could
work
be cool.
both ways, though, because
Yeah.
then from the state side, you could say, well, the trooper wanted to buy this property, and because he was rightfully asking over and over again to buy the property, that pissed off the defendant, and so the defendant was just mad at him because he was buying up all the property and shot at him. That could be a
Yeah.
motivation for the defense too, or for the defendant. That could go both ways, but I feel like it's more so on the trooper side. The trooper was just puffing his chest out. I'm
The-
Superman.
The trooper was pissed off that he sharted his pants because he's a moron, and even a person that doesn't hunt knows you don't go slinking around the first day of deer season when people are Pabst Blue Ribboned up and looking for a deer, and you could look like a deer.
Now in Michigan, technically, all you need is an orange hat on, but you're a fool
Well,
if you're just walking around with just an orange hat on.
Yeah, that's what I asked the hunters. I was like, "So what is the minimum requirement? Like, do you just go out with hair like mine? Like, what do you do?"
Yeah.
And they said, "You are lawfully required to wear an orange hat." But the fact that he was also wearing dark clothing, it was lightly snowing to medium snowing. So not a full Canton blizzard, but, visibility was obscured. And you are slinking around acting like a trespasser. I award the defense the dumbass defense, not for him, but for the state trooper.
Like when you're doing bow season or black powder season in Michigan, you don't have to wear orange.
Oh,
But why not? Why not?
Yeah.
You know, oh, well, you know, no one's going to shoot at me with a bow. No, it doesn't matter. Wear orange. And then you have a really good excuse if you happen to get shot by a bow, you know, or with a bow. So, or an arrow rather. So it's just nonsense. Just wear orange out there, people.
Yeah, it
Even
was
if you're
just, it
not
was,
hunting, if it's hunting
yeah.
season, wear orange out there.
Yeah, again, you don't want to be mounted holding the rifle that shot you in someone's someone's living room. And
Exactly.
yes, in Indiana, that is a decorative achievement.
I would rather be alive in clash than dead but you know, my outfit matching. So
Yeah.
well,
But that
hopefully I
was,
answered all of your questions that you
yes.
had on the actual case that you were covering.
Yeah, no, you did. I just, because it's nice because I didn't really know if discovery delay was maybe just a big case thing, and that I could understand with all the digital evidence that is now becoming almost a requirement, like DNA. I mean,
I will say
trial watchers.
one other thing about this discovery delay or whatever is like it's all a lot of times they say, oh, I don't have it, that person has it. Well, I don't have it, that person has it. And so that can be a pain in the ass. But again, we're talking about, on the cases that I handle, fairly minimal amount of discovery, not a lot of things. But when you're high volume cases, which tend to get the high profile cases, you know, one and the same, then it becomes a real issue. So if I send over a discovery request to the prosecutor and say, hey, turn over videos, and they respond, well, we don't have the videos, the police department has the videos, you have to go fill out this form and send it over to them. If it's just a couple of videos, it's no big deal. If it's something else, if it's a ton of stuff, or if it's a capital case, and more importantly, if it's a case that the prosecutor or evidence that the prosecutor intends to use, then they must turn it over. So they don't have that excuse anymore, but they still use it. Oh, well, you got to go get it from the police department, or you got to get it from the sheriff's office or whatever. Sometimes it's a cat and mouse game, and just the volume of discovery can amplify that. But it is just a bunch of BS, because when I do civil cases as the plaintiff's attorney, I turn over everything I have right away, because I want to convince them to like settle the case, take a plea, you know, resolve this. You know, I'm okay if it doesn't go to trial and I get everything I want, so long as I get something. And that's
Yeah.
kind of what the prosecutors are doing. So just send all the stuff over right away. Why do you got to wait for a response? Why do you got to play these games and say, well, we don't have it, you got to go over here? Just turn it over and be done with this.
Yeah, that's kind of, I mean, I think it may be more nefariously motivated, say, in the Delphi case. This case looks like it is more a factor or a function of this DA not having any administrative skills, because she basically put one lawyer on this giant case with a baby lawyer. But the, grown-up lawyer also still had a full countywide felony docket. So he was switching his time between this. She refused to go to the county, I guess, budgetary board to ask for more money to put a team on this. She refused to go into their, sort of rainy day defense fund for more extensive cases. So all of this goes back to her being terrible at her job, because she barely ran any cases. She took, I think, property cases in a county. She didn't do anything, but apparently go to the media.
Yeah, apparently, yeah. She spent all of her time on Facebook, or not Facebook, on YouTube and whatever, arguing with people in chat. It sounds like. I'm gonna check out this Jules with True Crime. Is what it looks like.
Yeah.
The channel is.
Yeah.
Do we know what day? Like, did she make an actual appearance, or did she sit for a pre-recorded interview? Do we know any of that?
So it looks like sometime after September 14th, 2021, she exchanged Facebook messages. We don't have the exact date, with Jules Wolfe. Looking down, it looks like she didn't actually go on Jules's channel, from what I remember. That she just wanted her to correct, the fact that the respondent did actually read the arrest affidavit, because I'm guessing, I haven't read, this is a case I'm going blind into. There are so many cases that, you know, some of them I can't cover them all. So I decided, with this disbarment coming through, or potential disbarment, I would kind of go into the Suzanne Morphew case more on the document side, so the probable cause affidavit. But I did want to start with how the investigation kind of went foobar from the start, at least on the DA side of things, to have a real Wolfram, you are safe. You are our dog Sith Lord. You are in no way related to Jules Wolf.
I'm just trying to look through her channel here. I'll find it. I'm gonna check it out. But
Did you spell it Julez?
yeah, it's Julez with, well, the channel I found was Jules with True Crime.
She switched it up.
Julez. So I don't know if that's the same channel or not. Now the videos go back 3 years, but the lives only go back so far.
Well, and then Profiling Evil is the YouTube channel where she actually went on and discussed, and then went Reply Guy. And I believe that was on, let me get you the date. August 30th, 2021 was when she went on his channel. I need to write that down too. I love my handy dandy sticky pad notes of truth.
What's the case that they were talking about at the time? What's the name of it?
The Suzanne Morphew case. Too long didn't read. Wife disappears from a bike ride on Mother's Day. Husband and wife were not in a great marriage. She has a lover. They can't find her body. They make an entire case against Barry Morphew, but don't give the defense any sort of. Basically, they foobar this entire case up. They didn't get their expert. The what?
What was the date that she went on that? August 30th, 2021.
30th, 21. Yeah.
Okay. I'm back in May, but I'm close. We're gonna find this. We're gonna. I might. Wait, hang on. Okay, so this is the stepbrother. What's the date? Is this? That's May 14th. Oh, I'm too far behind. I gotta scroll up. Then she gets into a ton of Daybell. I'm gonna find this video.
Yeah.
This
well, I think he might have pulled it down. I mean, I can imagine that if you are just a YouTuber who rambles about true crime and you are suddenly brought into a disbarment, hearing, you might pull that ish down just so you can get away from all the drama.
So he does a bunch. So apparently at that time there was a preliminary hearing going on because he was streaming the hearing. August 30th, 2021. Ooh, I found it.
Yeah, well, she was going over the preliminary hearing, and I guess.
Okay. Hang on. I'm going to send you a link to it in private chat. So if you want to check it out.
Oh, cool. Yeah, this is beyond the pale. I never in my life would I think that, an actual district attorney. I mean, I don't know why I'm shocked. It's not like, he calls it choir. Huh? Yeah, I'll have to look through it. He calls it choir practice.
Yeah, I'm not doing the sound, but that's her, right?
Yeah, that's her.
Yeah. So
it just
sound for quite a while. I don't know who this other guy is. Mike King.
So Mike King is the Profiling Evil guy. I think he used to work, I could be wrong, in behavioral analysis. So he likes to give people sort of the behavioral analysis. Maybe he has a psychology background, sort of, why this guy is, as we all like to say, a narcissist and a psychopath, without really, respecting the Goldwater rule ever.
It's a preliminary hearing discussion with DA Linda Stanley, choir practice number 50.
I'm going to be downloading
August
that.
30th. Yeah, I know, right? That's what I was thinking.
And in no way do I encourage anyone to go and give him any grief. Look, I would be sorely tempted if I had a best friend who was a prosecutor and
Well, I was going to say, as a YouTuber or a former now retired YouTuber, if a DA or a prosecutor wanted to say, reached out to me and said, "Hey, I want to come on your stream," I was like, "All right, come on, you say what you want to say. It's not on me; it's on you." So
True.
I don't share, or I don't condemn Profiling Evil for getting the DA on. I condemn her for getting on and talking about a case that she's clearly handling and in the midst of.
Okay, what about the inside baseball talk behind the scenes? What is the sort of thought about what do you think about that? Where she's telling him like, okay, we're pretty sure he didn't use the gun, but maybe he strangled her. Keep thinking of scenarios. I mean, these are text messages that she's sending someone who is not a party to the case. She's
Okay,
telling him how
so think about this. Let's assume you're a defense attorney and you've got a criminal defendant, and your job is to represent him and get an acquittal, right? Now, you are texting and putting out there in the public your trial strategy. Well, maybe this. If the prosecutor says this, I'm going to attack it this way. If the prosecutor says that, I'm going to attack it that way. And you're putting out trial strategy and essentially giving the world, and more importantly, the prosecutor, heads up on your trial strategy. Are you serving your client? No, you're not. Now, if it was a coordinated attempt to throw out some red herrings or whatever, it could be seen as a strategy or something like that. And there are reasons to issue like a press release and say he's not guilty. It was the one-armed man,
okay.
But generally, if you're just out there spouting off, you're probably not doing your client any favors. Now, flip that. Who's her client? Her client is the state.
Yeah.
And so if the state's objective is to incarcerate criminals, and let's say the state's position is this guy's actually a criminal and he gets acquitted now because of what you were just throwing out there, all this trial strategy and whatnot, then you have actually violated your ethical obligation to your client, which is the state. And so the state could fire you, or your county could fire you, but also that's a violation of the ethics rules. And so you could get disbarred.
Now, I did have a question, just sort of. I noticed that there was a sort of theme with the defense. The defense on my trial was two females, but it was definitely a theme and a strategy to paint this man as, David versus Goliath. Now, me knowing about trials, I know this is the case. But I think they did a really good job of taking lawyer speak and making it people speak. Do you practice that? Is that something that you sit down and maybe strategize? Like, what am I looking for in a juror? Do you go in case by case, kind of thinking, I would like someone who has maybe these kind of thoughts or doesn't have these kind of thoughts?
Okay, so whenever I approach a case, whether it's civil, criminal, defense, plaintiff, whatever it is, what is the story, the message that I want the jury to believe at the end of the day? What is that? What does that look like? Let's put that into common parlance. Let's say, what the story is. Then we do have a lot of legal things, but we also have evidence. So what evidence is going to get us there? What evidence is going to paint that picture for the jury? And how is that going to come together and fit together? How do we want to present it? Like, which witnesses do we want to call to introduce which exhibits and things like that? How do we want to paint this picture? And so then we have all of that in mind. So at very early on, you're painting this story. So for example, in the CSC or not CSC, in the child abuse, domestic violence case, it was the victim was a 16-year-old kid that was physically fighting his dad after stealing his vehicle the night before, and was already on probation for drug paraphernalia, and was getting into fights at school and failing out of school. And it's him and his wife, which is the victim's stepmother, because the mother's out of the picture. That's the story I want to tell. And so when the child says, "Dad beat me up," that's not the story that I want the jury to take away from. I want them to see a troubled child with a father trying to do his best, and that when he approached his son about stealing the vehicle the night before, the child got angry, started throwing things, and the father was defending himself. That's what the story is that I want to hear. Now, there's a bunch of technical legal things in there, but that's what I want the jury to see and take away from and go back and be like, obviously he's dealing with a troubled kid and trying to get him help and is at his wit's end, and the child was going berserk and he had to defend himself. So now when I'm picking a jury, I'm thinking, well, I want parents that might have a teenager or someone in their, a kid in their 20s that just went through teenage years. Stereotypes play a big role into this. So I might not want somebody from, say, a very affluent neighborhood that their kids go to private schools. I want somebody that's more of a blue collar sort of neighborhood.
Okay.
And so, but once you have that story in your mind, this is what I want to convince the jury, then you can start developing demographics for the jury that you want. That's how I approach cases, and that's how most trial attorneys, I would imagine, approach cases. We actually have like these little mini trial colleges and stuff that you can take when you're in law school, and they teach you these kind of things. And so, but as far as converting everything from legalese to common, understandable language, that's just sort of a personality trait that some people have and some people don't. When you get out of law school, you have like 3 or 4 options. You can be like do trials. You can do corporate law where you're just, sitting and reviewing contracts. You can go into some sort of public service like a judge or something. Or then you could say what's working in the stacks. So that means like you don't have a good persona, but you really know the law. So you sit back and do the research and all the typing. And depending on how your personality works, you should be doing this. But often I see people that probably should be in the stacks are out there trying cases, and it's not a good mix.
It really does. I will say that I think the lead defense attorney did a really good job of portraying herself as she had actual knowledge of hunting. And I think it was really a smart move for the defendant to pick her. I don't know if he picked her because she knew, but she was a range mommy, which I had never heard that term, but now I desperately want to be one. Which will require me to actually fire a firearm.
I think we got a nickname for Mo.
Well, I've never been to a range, so I would have to actually go to one before I could be a range babysitter. Now, Mr. Mo is actually doing range babysitting for officers today, so he's going to come back in a great mood because officers, we had a firearm display and I was waiting to get tagged by the entire prosecution team. I was waiting for them to, light us up all through, but they didn't even take it out of the damn box. I was so pissed off. I was like, you're not even going to light us up. Why did I even join this trial?
Nice. Well, yeah. So, I mean, everyone's got sort of their different strategy. And if you watch the Jennifer Crumbley trial, I wasn't a fan of her attorney's sort of style, but I don't know.
I think if she had toned down a little bit the personal stories, if she had painted the picture of an overwhelmed mom and not put herself in it, I think she put herself in a lot, and I didn't particularly like that. It did humanize the case, but I think it could have been done better and with less emotion. But Crumbley, unfortunately, she dug herself her own grave when she said, I am a victim too. And I was like, son of a whore. Did your lawyer not tell you? Her lawyer is out like, get me the gin. Get me the gin. I
wouldn't have changed a thing having known what happened. I wouldn't have changed a thing. It's a bad answer. She did try to walk that back a little bit after the fact, but that came out the gate and she was done. Yeah, that's true. But, everyone's got their different style. But so like that case, right? You'd want to get people, not necessarily that are from Oxford, but other rural communities, hunters, people with kids that have guns. Those are the demographics you want to go for like jury and things like that, because that's a story you want to tell. Parents that are working, that have a teenage child that doesn't necessarily tell them everything all the time, that have guns in the house, that are hunters and things like that. So you kind of build a demographic in your mind.
It just seemed like her, and I didn't
You,
watch the
you
entire
get you
case.
get the vampire off the jury. I'm just saying,
Yeah.
that ended up being
Well,
the foreman.
Yeah, I know. Again, I thought I would be disqualified with this hair. I figured I was like, who's going to profile me and put me in Antifa? Because
Is that your
you're going
real
to be.
hair now? That's not a wig.
Yeah,
Your hair's dyed.
that's not.
Okay.
It's not a wig.
I'm
I
just used to
spent
you
money.
wearing wigs all the time. So
Well, that's what I told the lady who did my hair. I was like, "Don't worry, sweetie. If it messes up, I've got like a shit ton of wigs. I really don't care. I am paying for 5 hours to sit in a chair and have no one ask me anything like, can you open me a snack pack? My brother hit me. None of that. I am here sitting down in a chair doing not one mom thing. That is all. If my hair turns out looking okay, but I am literally here to be away from everyone for 5 hours."
oh, all right. I've got to get back to work, but I was happy to hop on. Thank you
Well,
for the
thank you
insight.
so much. No, this actually really clears a lot of things up because, you see things on TV and then you actually sit in a courtroom, and it got me thinking, okay, if I were a lawyer, how would I approach this? How do real lawyers, do they give you like classes in drama? Do they kind of tell you, hey,
They
like,
should. They should. And in fact, I had at the time I graduated, I was when I was married to my previous wife. Her sister-in-law was an acting coach, and I approached her and I said, "Listen, we should really put together a program teaching lawyers how to act, and just at the very least, publicly communicate." Because I
well,
went to
that
law
and
school with a
understand
bunch of
your,
duds. I don't know how they're going to try cases.
well, but understanding your audience, understanding your target audience, and then changing your approach, because a city lawyer, would not have worked in our county. The fact that she had her bona fides, as far as I have firearms, I used to do a range, I used to hunt. I mean, she had her bona fides and she played to that, and I think that was a good strategy. But it does seem like you need to have maybe the ability to understand your audience, understand your target audience, and change your, not your self, but your delivery to get your message across. And I think that Crumbly's lawyer didn't change enough. She didn't show enough empathy.
She wasn't reading the room. I could understand
Yeah.
if, like, in concept, this is your theory, and then, but once you approach the jury and you start communicating with them, and particularly the judge, when the judge was, when the prosecutor was jumping up in front of the jury and objecting to whatever emotional outburst that the defense attorney is making, or and the judge is addressing it even outside of the jury presence. Okay, take that as a cue and start changing your
Yeah.
behavior. And she didn't do that. So you need to be
No.
able to adapt as well.
Well, and that's like if you get a chance to watch the Samantha Wall case. Now, the state failed to prove anything other than he lied to the police. So this was, yeah, this was a high profile case, I believe, in Michigan. So I believe it's near your, or maybe it was
Wait, what's the case?
Detroit. Prominent, newly elected Jewish president of the, I think, Ben Israel synagogue, but I could be very wrong, so don't quote me on that. She was found with a significant amount of struggle and blood in her apartment. She was found in front of her apartment with multiple facial and neck stab wounds.
I remember
They
that
tried.
case. That was just a few months ago. That trial.
Yeah, well, the guy they got up there, they didn't prove a dang thing, and he basically got a.
But you're
got
not from
just
Detroit. Everybody knows he did it.
well.
No, but that's like that's the news media here, right? Was everyone's
Oh
like,
yeah.
oh, this guy obviously did it. We're just waiting for the story as to how and why he did it.
Well, yeah, and that's what I think is really great about having LayTube, LawTube, all of these different disparate sources, because it's waking up people like me. You watch the Rittenhouse case, you watch the Potter case, you watch some of these cases, the Anderson case, and you see that there are a lot of shenanigans going on. And it kind of opens your eyes to, wait a minute, this isn't Madlock. This isn't, a TV show. there seems to be something wrong. I can't put my finger on it. And now that we have lawyers that can stop and say, this isn't quite right, or they didn't make their good point here, or, this is the standard to which they're held and they haven't really proved anything. Now, regardless of the juries actually pay attention to us because they seem to not,
Right.
we're all like not guilty and everyone's like guilty and burn them at the stake.
I know, it was so frustrating when I was streaming trials. It was just so frustrating. I got visibly upset on a couple of verdicts before, and I was just like, no, oh my God.
It's hard because you get invested, and it was never more real to me than when I was sitting in the jury seat and watching this man have a nervous tick. That that I hold in my hands his future. I mean, I didn't sleep well the night before I had jury duty because I knew what I decide can affect an entire family. I wasn't aware of what case I was going to have, but I was like, I could, have to take someone's freedom away. This is a big deal. And it was heavy. I mean, it was like, okay, this is an actual job. This is something, that is really important. And I think everyone on the jury approached it as such. But there are juries that are just like, oh, no, the state said this.
I know. And it's the high profile ones. Like, I've never been on a high profile case. I haven't even been called to jury duty anywhere where there was like a high profile case. So I don't know how I would react with that. But given my position on cases that I'm publicly throwing out there, I don't feel like I'd be persuaded by, news media or whatever, not liking me because I, pushed back on if I was sitting on, say, Jennifer Crumley, and I, for whatever reason, was able to convince everyone else to say not guilty, I'd be okay with it. But not a lot of people will be. A lot of people are, I don't want to make waves here. And it's the I don't want to make waves people that end up just like, well, we'll just go along with whatever's the easiest path.
Well, then should we sequester juries on big cases? Because I know we haven't been sequestering them because it is, a big inconvenience and it would lower the jury pool of willing people.
No, because by the time that the jury is actually selected, it's already been in the news media for years. So it wouldn't make any difference.
Okay, I have an idea. We only get the jury pool from the Amish.
There you go. That's what we do. There's an idea there's an idea of a mixed, I'm not necessarily clearly opposed to the Danish system, like Baker, the broken
I like
Baker.
The Danish. Yeah.
He's a professional juror, and he sits as a professional juror with a judge or two judges, depending on the type of case it is. And so it's the jurors and the judge, and they discuss the case. Now, I don't want to go that far, but the idea in my mind is professional jurors. Like if you have 12 people, you have 6 that are lay jurors and maybe 3 professional jurors. Or,
I think
so like
that would be a good mix.
Or something along that line. I feel like could I don't know. It could be a disaster, but it could also be better. I don't know. Let's experiment.
Yeah, let's have that. I think it's great that we finally included jury questions. Now, we didn't have any jury questions, mostly because I thought this case was dumb to begin. I was like, how is this a case? I was like, can I ask that as a question?
Right.
WTF are we doing here?
Yeah. Maybe in a few years I can talk about a jury question situation that I had personally. But I gotta, let everything settle first.
Well,
Jury questions are good. I like them as a general principle. I think they should all have them. They can influence the case too, which is a good thing. So it's I like jury questions a lot.
Well, I think it shows holes in the case, both for the defense and the prosecutor. If
Right.
you are getting a lot of questions, about the validity or clarification, then it's kind of a sign to you that you are not explaining or asking the right questions. I did hear a couple what if anythings, and is it fair to? I was like, you've made my day.
Oh, what if anything? Yeah, those are great.
Well, I am going to shut down the stream because I am stalking my replacement package of medicine. We had a porch pirate, so I have to make
Oh,
a police report, which is nice. But apparently, I have like 3 sticky notes on my door, like, please knock on door and I will come get package. Do not leave on porch. Thank you so much. The last one got stolen.
Well, you have fun with that. And yeah, have a good rest of your day. Everybody in chat, I'll jump off so you can end your stream and
Okie dokie.
get back to work.
Sounds like a plan. Go lawful law.
Yes. Take care. Bye.
Bye. Well, guys, we kind of got sidetracked, but I really did like kind of having a real lawyer explain some of the things and give insight. We got off on a tangent. You know me. Oh, crap. I still have Rack of Justice up. Of course I do. Oh, Lord. If you like MLS, he is so very knowledgeable and he is a lawyer, a real lawyer. So he also does Lego stuff. He doesn't stream as much as he used to because, again, he is a practicing lawyer with a real job. But he does these really interesting Lego builds and interviews with people, that he just finds interesting. And I think that's so cool. So check those out. And I will see you guys not this evening, but I will be putting out a couple of short videos. Apparently, Flare Me at 3 a.m. ordered me the entire collection of Sailor Moon makeup. So thank you, Flare Me. I get this package. I'm like, what is this? I opened it up and I was like, I will share this with the community. But also, we have a new Sarah Boone motion that may make me giggle like a 6-year-old girl. So if you want to see those, I will be working on those videos as I am waiting for the delivery of my package. And I will see you guys tomorrow morning for Mornings with Mo. And we will get to, it looks like for tomorrow, I did put up, we're just going to try some interesting things. We are going to look at the interrogation of Wade Wilson. I'm just kind of trying to do a potpourri of cases that I haven't really gone into. I know a lot about the Delphi case, and sometimes I feel like I'm saying the same things over and over again. And I also like kind of having a fresh perspective where you guys may know a lot about the case, the internet may know a lot about the case, but I'm kind of seeing it with new eyes and you guys are teaching me things. I really like that dynamic. So it's something that I'll be adding more in. And hopefully by tomorrow, my X account will be blue check marked again. They've received my $11. And I will feel good about I don't care if I've got a check mark, but any hoozle, I will see you guys in a little bit. Take care of yourselves. Be kind to yourself, be kind to others. And if people are jerks, screw them. Bye, guys.